The bell. Okay, welcome everybody to our second panel of the day. I have to say that we think that bashing capitalism for 5 minutes in the morning is going to be instituted alongside yoga for 5 minutes in the morning. That is going to be a systematic practice. Okay, we are going to present some of the findings of our project PluriLand, which is about contestations over land in plural land regimes. This is a project that's financed by FreePro, run through here, and part of Law Transform. And I'm Rachel Cedar, and I'm coordinating the project. And I'm not going to have enough time because there are 5 of our participants. So I'm really not going to have time to kind of say very much about the conception of the project for you. But I guess why land rights, right? We've done lots of work on the ways in which social movements use law, framing, courts. Why land rights? Well, you know, as we know, in many of the parts of the world that we work in, property rights, even though we have protective rights regimes in constitutions, particularly for Indigenous people's rights and Afro-descendant rights in some parts of the world, that property rights still tend to trump everything. We've talked a lot about extractivist regimes, sacrifice zones, colonial legacies and path dependency. Land rights is, you know, a kind of crystal to look at the interaction between law, lawfare, and these long histories of longue durée. We've been working for 3 years now. Yeah, we have another 2 years to go on the project. I guess, all are focusing in different ways on the interactions between land regimes, what we call land regimes, these legally plural constellations of norms and sites that govern land ownership, access, and use. So formal and informal forms of regulation around land, looking at who's mobilizing, how they're litigating, if they're litigating, against whom they're litigating. When we started, we've been trying to build a comparative multi-factor typology, looking at types of framings that are used to pursue different land claims, and the legal sites in which they're disputed. And then we've also been having a long ongoing discussion about how to approximate the transformative dimensions, the effects and the diffuse effects of socio-legal mobilization around land. You know, that raises all kinds of questions about transformative according to what perspective and whose perspective and what kinds of timeframes and what sort of process tracing. And I don't think that we've resolved those questions in the work itself, but we've certainly been having some really important and interesting discussions about that. We've made I don't have time to show it to you here, but we have developed a comparative matrix for the process tracing of socio-legal mobilization around land and territory. And in terms of looking at the transformative effects, we're working with Nancy Fraser's idea of recognition and redistribution, and we're trying to ground that in some of the things that we're writing at the moment. We're doing 2 comparative review papers we've been commissioned to do for the annual review of law and social science. And then we have a special issue in Train on the different case studies, which you will hear about now. So in the interests of brevity and time, I'm going to stop there and open the floor to Tatiana Alfonso, who's our first speaker, who's working on the case of Colombia. Tatiana... She was surprised? Tatiana is... no, she's excited to be here. It's just... It's 2 o'clock in the morning in Mexico City. So welcome, Tatiana and Trooper. And Tatiana works at CIDE in Mexico City. And Tatiana, the floor is yours for 5 minutes.
Thank you so much. And thank you for facilitating everything so I could connect here. I'm surprised because I was not expecting to be the first. But I guess I'm gonna use the first 5 minutes you said, right? Just to try to explain what we have advanced and found in the Colombian case. Thinking that, I guess at the beginning, as when we started thinking about plural legal regimes and different land regimes that we have, Colombia is one of the paradigmatic cases in which you have several legal regimes over land, most of them endorsed or issued under the framework of property rights, I would say, but in which you have a lot of potential transformative ideas in terms of who has the land, who owns the land, who has rights over them. However, what we have seen with the empirical analysis of the cases, especially judicial decisions regarding peasants, indigenous, and Afro-descendants, is that there's a lot of judicial decisions that protect rights over land, and how most of them, however, are limited to symbolic recognition, and of course, the adjudication of land rights in the Colombian case have had, as so many other issues, a clear obstacle, which is the ongoing conflict, right? So one of the main issues in the Colombian case is that even when you have a lot of judicial activity, a lot of progressive jurisprudence over land, and tons of hectares that have been granted to indigenous peoples, Afro-descendant, some of them to peasants, we're still seeing the same frames in the past years. So we saw new frames in different moments with different laws. But now what we're seeing, what I argue we are seeing, is that most of those frames have been stabilized. So they are not changing anymore while the ongoing conflict keeps changing. So there's protection against what used to be groups that disputed land possession, land property, but now those frames are not being enough for the new actors that are disputing the land on the ground. So I think that's one of the important issues when we're looking at transformative or potential transformation over land regarding land regimes, because even when the frames used to be new by that time, they are not new anymore, and they don't seem to be useful for the situation and the conflicts between actors disputing land on the ground. And second, just to start, I would say that part of the issue, which is of course not surprising, especially for this audience, is that the enforcement of those judicial decisions have been really doubtful, I would say, at least. Basically, because most of them depend, of course, on state agencies that implement and develop the rulings. And as we have seen, well, I guess we have our first leftist government in history, in the Republican history of the country, I would say. And that was actually, there was a lot of hope for implementation and development for land reform. And even in this government, the implementation and enforcement of the decisions have been really weak. No, so we're still seeing the huge gap between the decisions that at some moment were progressive, noble, completely different in terms of framing and actors and guarantees, but we don't see not any, I would say, but we don't see enough state movement by state agencies in order to implement. So I would say the transformation still pending as usual, but it's especially blocked by the lack of state action state action for granting and implementing those rulings. I would start with that.
Great, thank you so much, Tatiana. Oh, that's wonderful. Anna Braconnier, who's a fellow here at Law Transform and also from the Universidad Rafael Landiva in Guatemala. No.
Thank you. So I would say that in the Guatemalan case, so the paper we're working with Rachel, and the question that drives our research in Guatemala is to what extent international law have allowed for more transformative land justice for indigenous peoples, which is a very traditional question in the literature and in our scholarship. But what I think we are a little bit trying to be innovative is that the literature on outcomes and effects and litigation have focused on the impact on policy making or lawmaking. And what we are trying to understand is a little bit beyond the law and the policy. And we, in the Guatemalan case at least, we assess the transformative land justice outcome relating to the strengthening of indigenous self-government and self-determination over territory. So the Guatemalan case is a case study where international law, especially ILO 169 and the Inter-American Court of Human Rights decisions have been taken seriously and very much legally mobilized. And mainly the right to free, prior, and informed consultation, as well as more now innovative way of litigating the right to ownership and possession of land. So in Guatemala, lawyers mobilized international laws, but also domestic laws, like in parallel. So in the Guatemalan case, we have looked to our database is more or less 40 cases. And the two figures that we see that have been mobilized are, so the right to free, prior, and informed consultation, but also like a bundle of rights to guarantee the right to ancestral land recovery. So the mobilization started in the early 2000s. So now we are assessing like more or less 25 years of litigation, cases that arrived to the Constitutional Court, which is the highest court, but also the cases that have been mobilized to the Inter-American Court of Human Rights, and we have recently a new decision that we need to study more carefully, and we are waiting for another case, which is the one about ownership and possession, that will probably come like in 10 years or something like that, so very late. But we'll look at that too. We look forward to it. So with the field work that we have done in Guatemala and this database study, what we have observed so far is that disputes over land, of course, are 20 years ago. We were expecting that international law would have a very important impact in not only in the case itself, in terms of recognition and redistribution, and with the assessment that we have been doing, we see that that is not really happening, and that international law has been very good for the recognition aspect of indigenous people's rights, but redistribution, not that much. And that in the cases we are working on, I think that domestic laws, surprisingly, has been having much more effect in stopping extractive licenses and in redistributing land, collective land, of course, in the figure of private property, but collective private property, which is interesting. And yes, so the third thing that we have been trying to make categories to understand what does transformative justice mean in the land claims. So I guess that the main focus of the paper is the study of the diffuse effects of law and legal mobilization in three terms: the possibilities for self-determination, the amplification of the voices of marginalized sectors in the public sphere, and the alternative narratives over land ownership, use, development models, environmental damage, governance, which actually is like the most positive effect of law mobilization and international law mobilization specifically. Thank you.
Thank you, Anna. Next we go to Jackie Dugard, and Jackie's working on South Africa. Jackie, all of you know, I think that she's at Colombia at the Center for Human Rights and still at WITS as well.
Thank you. So the South African case that I'm focusing on takes as the starting point the 1996 constitution, which some of us, myself included, have called a transformative constitution because it sought to fundamentally transform all relations, civil, political, socioeconomic, from a colonial apartheid state, which was based on racial supremacy of the white minority, and a massive component here was land. So under colonial apartheid, approximately 88% of land rights were dispossessed and transferred forcibly to the white minority. So the question then occurred, what to do after 1994 and the democratic transition. And this was one of the major elements of the 1996 constitution, was the question of land. So section 25 of the constitution, which many of us call the property clause. I'm a property law teacher, and we always refer to it as the property rights clause, but in actual fact, it should really be called the land clause, because it has 8 subsections. Only subsection 1 relates to property in a sort of a old guard, white private ownership sense, in that you cannot be arbitrarily deprived of property. It's not a positive right to property. And all of the other clauses relate to actually a constitutional mandate to advance access to land in various forms. And what I'm specifically working on in this project is how has land been treated by the courts. So one of the post-apartheid institutions was the establishment of a specific land claims court. The idea being at the time, and I don't know if Ellen is here, yes. So I'm really interested to know whether this resonates elsewhere, because this is one of the contributions I'm hoping the study might make, is this question about when you have a specialized land claims court to deal with these massive questions of land redistribution, whether or not that having a specialized court works. So that's one of my central questions. Now, in terms of its jurisdiction, the Land Claims Court deals with 3 pieces of legislation, all which were enacted pursuant to Section 25 in terms of advancing access to land to historically disadvantaged and marginalized groups. So it's the Restitution of Land Rights Act, which is about restitution to anyone whose land rights were dispossessed. as a result of racially discriminatory laws or practices after 1913. And also then two other pieces of legislation, one called ESTA, the Extension of Security of Land Security of Access Act, which so Land Security Act, which basically is about extending tenure security, and a similar one, the LTA, the Labor Tenants Act, which is about securing the rights of labor tenants, which is all essentially around entrenching and advancing access to land rights for historically dispossessed groups. So when I look at the cases that have come before the Land Claims Court, and the Land Claims Court has jurisdiction over all three of these pieces of legislation, you see an interesting story. And just as a short side, one of the criticisms, not everybody agrees that the Constitution is transformative. Those people who disagree that the Constitution is transformative, many of them focus in on Section 25, the property rights clause. So, and many people also find that the over-reliance on courts as the mechanism of transformation, the engine, is problematic, and that courts are counter-majoritarian, elite, etc. So that's one of the other interesting pieces here, because what you see is in every one of these cases, you see that ultimately, when it comes to the constitutional court level, so I have looked at cases that have gone through the Land Claims Court, the Supreme Court of Appeal, and the Constitutional Court. So the Land Claims Court, a specialist court set up as a transitional justice mechanism to deal with land redistribution, etc. The Supreme Court of Appeal, an apartheid institution, and the Constitutional Court, another post-apartheid institution, but not a specialist land court. So when you look at how the same case fares over these three different courts, what I've picked up now is that the Land Claims Court is the most conservative. The Supreme Court of Appeal, so that goes counter the hypothesis, completely counter the hypothesis. The Supreme Court is something in the middle, which is, it's not as conservative as you might have hypothesized. The Constitutional Court is the most transformative. And what I still have to sort of unpack why I think the Land Claims Court is the most conservative and what this means for transitional justice. But what I think in general you can say about the courts dealing with land issues, particularly the Constitutional Court, tallies with other work I've done on socioeconomic rights and also on informal land rights, housing rights, Indigenous land rights, which are not under the jurisdiction of the Land Claims Court, is that essentially what you find is that you have communities pitted against the government. In other words, the government is being the counter-majoritarian force. And it is the government that is failing to advance land rights and access to land. The courts are, in almost every single case, ruling in favor of the applicants, the communities. So I'll leave it there.
Thank you, Jackie. Next up, we have Namita Wahi, who is a fellow here at Law Transform and from CPR in India, and she's going to talk to us about the work on India.
Thank you, Rachel. Thank you once again to CIRI and Law Transform for having us here, and to all of my colleagues on the project. So plural land regimes are an ubiquitous feature of post-colonial states, and that is because of the nature of colonization as a process of appropriation of the natural resources of the colony for enabling the social and economic development of the colonizer. However, the process of colonization in all of the countries that we are looking at was met with continuous resistance by the colonized people, as a result of which colonial legal regimes were unable to effectuate a complete erasure of pre-existing legal regimes. At the same time, post-colonial states did not start with a clean slate, even as they began their independent existence with a commitment to reverse centuries of injustice of colonial rule. They inherited a baggage of colonial legal and administrative frameworks that could only be reversed through democratic consensus, and only insofar as the changes were justified within the hegemonic narrative of economic development. So development in some ways is the new colonization that these post-colonial states, now developing countries, aspire to. Now, most colonies in the world can be classified into settler colonies, and that would speak to the other case studies that have been mentioned so far in Latin America and South Africa. and conquered colonies. India is an example of a conquered colony. And we were conquered by the British. Speaking of capital this morning, first by the British East India Company for 100 years, and then by the British Crown. And I think what the British did in India was to pass a series of laws that, with respect to land, water, and forests, which were highly extractive in nature and focused on ensuring greater state control over the resource to maximize revenue, first for the British East India Company and then for the British Crown. Now, this state control was facilitated through 4 sets of laws: land acquisition laws, which authorize the compulsory taking of land belonging to private individuals by the state; forest laws that asserted state ownership over forests and derecognized the rights of forest-dwelling communities; mining laws, which asserted the right of the state to all resources in the subsoil; and irrigation laws that basically allowed for the appropriation of water resources for the purposes of commonly held water resources for the purpose of irrigation. However, this colonial policy and these laws met with considerable resistance from the people that they dispossessed, namely the peasants and the indigenous communities in India. Therefore, it happened in a piecemeal and historically contingent fashion over a country as big as India. Both the agrarian population and indigenous communities opposed this appropriation, but there was a key difference in the sense that the indigenous communities understood land as not only integral to their community identity, history, and culture, but also as being inextricably linked to water and forests. This notion of Jal Jangal Zameen. Within this understanding, land, one is that land, water, forests are part of one indivisible ecosystem, and the second is that human beings are not separate from the environment. Another reason for the plurality of land regimes in India was the British policy of divide and rule, which not only resulted in the exclusion of indigenous communities from the rest of the population, but also led to the recognition of diverse customary inheritance regimes for all religious and ethnic communities, including with respect to inheritance of land. Cut to 1950, we have a very progressive, we didn't have the words transformative constitution then, but I think the Indian constitution was possibly one of the most transformative constitutions in the world. Using Nancy Fraser's terminology, recognition of identity-based vulnerable groups and redistribution of land were key themes for India's emergence from centuries of colonial rule. Like other freedom movements, along with the desire to determine their destiny, the Indian independence movement was driven by the desire to achieve a new social and economic order premised on rapid economic development and social redistribution. Restructuring property relationships in land through land reform programs was supposed to be a key feature of this vision. Indeed, land reform laws were being passed by provincial legislatures in India even before India became independent. In his political and economic thought, Dr. B.R. Ambedkar, the chief architect of the Indian Constitution, and please note that he was the Dalit, he belonged to the untouchable caste. So the Indian Constitution was written by someone from the untouchable caste. That is akin to a Black person writing the US Constitution when it was written. So we can understand how progressive it was. In his social and economic thought, he emphasized the importance of both caste and class in creating poverty and inequalities in society. As a result, the Indian Constitution recognized and empowered vulnerable groups like women, Dalits, who were the untouchables, and indigenous groups, and was pioneering not only in terms of providing them constitutional recognition, but in the case of indigenous groups, also in enshrining special protections for land rights of these groups vis-a-vis the state, as well as other communities in geographically demarcated tribal majority areas known as scheduled areas under the 5th and 6th schedules of the Constitution. The Constitution also provided for affirmative action provisions in state-supported educational institutions and government jobs for indigenous groups. As the world's longest constitution, the wealth of constitutional text afforded extensive opportunities for progressive lawyering with respect to social and economic rights. At Law Transform, through a series of projects on land rights in India, as well as a water rights project, which also involved Jackie and many others in the room. Essentially, we have tried to map the contours of social and economic rights litigation in India. And with this project, we are trying to advance the study of what is it about land rights claiming that is different from existing social and economic rights litigation in these countries, and also to specifically understand how social movements use the law. So starting with the matrix that Tatiana spoke about, I went ahead and classified cases on land rights claiming and land litigation, as well as indigenous groups bringing land claims. And ultimately, what I found, I've done extensive work on land litigation in India, where I found that the claims of indigenous groups were conspicuous by their absence. But at the same time, I did identify many cases. I'm studying about 5 of them right now, where indigenous social movements brought claims about land, but there were also claims about land, water, and forests, because these are inextricably linked, to the Supreme Court, because we wanted to identify under what conditions do these social movements bring these claims, and whether they win or they lose, but also like what kinds of claims are brought. And we wanted to have one common forum to sort of understand how and why certain claims have succeeded before the same forum and other claims have not. Does it depend upon the way the claim is brought? Does it depend upon who it is up against in terms of which state government, which central government within the federal system? Or is it dependent upon the time period within which these claims are brought, and so on? So trying to map those factors. And, there's very little literature on these social movements bringing these kinds of land claims. The very sparse literature that exists does talk about the plural legal frameworks and the, customary law that were there in each of these 5 different states, because like I mentioned, there's a layer upon layer of legal frameworks in India dealing with land, particularly because we have the colonial layer, then we have the post-colonial layer, and it's not necessarily the case that the colonial is always bad for the indigenous groups. It again depends upon which state you come from. And then you have the post-colonial layer, but it's a federal system. And so you have different layers as well. So sort of navigating through those layers and trying to come up with a series of findings on under what conditions do social movements succeed and under what conditions they do not succeed. Ultimately, just to conclude, social movements fronting the indigenous imagination have used courts as one tool in their arsenal. Social movements have used all other arenas that have been open to them. And this is something that goes back again to the social and economic rights litigation work that we have been doing at Law Transform for the past decade, because at least in our work on health rights and water rights, we have emphasized that courts have provided a discursive space for deliberation of the kind that Roberto talks about, to actually allow for groups that are marginalized to have that voice on the table, which especially for vulnerable and minority groups like indigenous groups, who are only 8% of India's population, who have some of the lowest indicators on social and economic fronts, are not really able to access the more the spaces where deliberation actually should happen, which is the parliament and so on. Therefore, courts have provided that space for them, but they have also used where they could in coalition government eras in between in the 90s and the 2000s to actually push forward the Forest Rights Act. The Forest Rights Act is a pioneering legislation because it sort of encapsulates the indigenous imagination of land, water, forest being as a part of one indivisible ecosystem. It recognizes individual and community rights to land as a legal right, as a property right, in fact. And it's interesting because it sort of pushes against this definition of property being individual and taking away property from common resources to returning it back to common resources. Thank you.
Thank you. I'm sorry to hurry you. We've got lots of us and lots to say on this project. So our last speaker is Elena Alvear, who is Professor of Law at Sciences Po in Paris. And we're delighted, Elena, to have you in the project. So
thank you. Thank you very much. So I actually was tasked with something that I feel is impossible, which is, I felt like Averroes in the very famous Borges story, which is try to translate all of this into some common themes, but I'm going to do my best here. So I think that what brings these cases together are 2 characteristics. So only from a constitutional point of view, this is something that I will continue to work on, but from a constitutional point of view, these are constitutions that are both transitional in the sense that they're transiting from either a conflict to a situation in which peace is trying to be achieved, even if weakly, as Tatiana was mentioning, or probably in Guatemala, probably in South Africa as well, or transition from a colonial period to independence with the difficulties that all of this brings, as Namita was saying. Now, transformative means from authoritarianism to liberalism in many cases, and the inclusion of social and economic rights and procedures to achieve them. It includes also, and it was evident in most of the presentation, diverse forms of property arrangements but also the social function of property, the ecological function of property. So at least these three characteristics: more of a liberal system, less of an authoritarian, the inclusion of social and economic rights, and the consagration of diverse forms of property. Now, there are two overarching preliminary observations that these transformative and transitional constitutions bring from listening and reading to the wonderful research that has been done. The first one is that despite the transformative and transitional ideals, the cases contain a structural bias toward classical liberal ideas. And by classical, I mean the centrality of the individual vis-a-vis the collective, the distribution of resources through the market more than through the state, the shielding of the individual from the excesses of state power, so this fear that the state shouldn't intervene too much, the definition of harm mostly in terms of discrimination, as opposed to exploitation, for example, and the promotion of capitalist expansion in all of these countries with its extractive relationship to nature. And I think that in all of the cases, this was prevalent in the descriptions. Now, this classical liberal bias produces very particular institutional arrangements, and that was also clear in most of the presentations, that are ill-equipped to embrace ideas about the collective, and that's why we saw tension with the collective in each one of them, and marginalizes economic alternatives, other economic alternatives, which we've been listening about, particularly even this morning, which we should, I agree, we should always start by bashing capitalism, experimental social arrangements that are very prevalent, for example, in a relationship to collective property, and importantly, diverse cultural ways of narrating nature and our relationship to it. And this has been talked about in previous panels as well. So that's the first idea, that there is more of a classical liberal bias. And what does that classical liberal bias entail? And what are the things that it is marginalizing? The second idea, and I think that that was also prevalent in most of the presentations, is that we've suffered from, and I've written about this in the context of Colombia, but I think it's equivalent in all places. We have too much faith on transformation through constitutional clauses and judicial interpretation, and less through other aspects that are relevant to land access. Particularly, and I'm going to mention a few, Tatiana mentioned, for example, the execution of rulings, administrative law, the institutional arrangements. Jackie talked about the different ways in which a specific concept is interpreted. Namita mentioned a range of, forest law, other types of law. So that's one thing. We are concentrating too much on the constitutional, on the courts, and we're taking less into account other laws, administrative law, institutional settings, private law, etc. But most importantly, and again, this was mentioned in some of the presentations, the effects of law set forth for economic development, that all have a very specific effect over access to land. Global capitalism that was mentioned this morning. For example, based on extractivism or agribusiness, huge in Brazil, huge in Colombia, that is going to go against specific understanding of property, and facilitated by trade agreements that we should be looking into when we look into access to land. And then finally, a very important issue that is a little bit of a paradox, because we tend to look at access to land either in constitutional terms or in terms that are related to collective property. What about the interaction between land, property, and labor? So there is a lot of literature about the fact that when there is scarcity of labor in certain agro-businesses, small producers are, laborers are transformed into small producers with, the terrible consequences that they get indebted, theoretically they're empowered because now they're producers, but they have to produce quotas. So it's not necessarily empowering to have access to land. Sometimes it can be worse to have access to land. And that's a final paradox I would like to end with, but that is my effort at bringing these together. Thank you.
Fantastic. Thank you so much, Elena. We have 15 minutes left from the panel, and we would love to hear from questions. And I see lots of hands up.
Okay, thank you. Thanks very much. Jackie, the Constitutional Court decisions have significant implications for land reform and plural legal regime in South Africa. But we haven't had expressed judicial opinion on expropriation of land without compensation. There is important literature by Temberger arguing that Section 25 of the Constitution permits expropriation of land without compensation in South Africa. But you have the ANC and other political parties who believe that we need to amend Section 25 of the Constitution in order to expropriate land to the indigenous people. Now, I have this question for you, and it would be interesting to hear your opinion. Is there a legitimacy in the debate about expropriation of land without compensation in South Africa? Is this transformative? Do we really need to amend Section 25 of the Constitution? Thank you.
Yeah, thanks very much, Jackie. Given the proximity and similarities with what is going on what went on in Zimbabwe and earlier attempts at basically coming up with a regional approach, remember the Land Tribunal, what could be the areas for sort of like a comparative analysis between what's happening in Zimbabwe and what is happening in South Africa? Because there are a lot of parallels.
This is grabbing. Now we're going to so many questions.
One quick question. In terms of the Nancy Fraser framing, why did you not include participation, which is her latest articulation? It seems that participation is probably the one. Oh, that's question grabbing.
No, it was the participation that since last year I was wondering why participation is not in the framework of and also just as the objective of the project, are you willing to have a claim of climate justice or another dimension in Fraser's work, restorative? So could you see that from your perspective as well? So that's it. Sorry.
This is also a call in line with Elena's comment, and it's a call for more structural approach. So 1 minute story. During the origins of judicial review, the main topic around was what to do with property and expropriation. And for Madison, it was very clear, and this is something we should be aware of. Okay, don't worry. I mean, he was telling to the upper class, don't worry about the demands you have, because, I mean, judges are coming from your same social origin. Because of the way they are elected, because of the way they are accountable, because of the stability of the positions, no worry at all. So he was thinking very well, I mean, in his way, that the structural elements were all going in this direction. So he was saying, so I would say, for those of us who want to believe in courts and the transformative power, what reasons we have to expect from this same structure to get the opposite results. So I would be there.
Thank you all. That was amazing presentations and so many questions. As you can see, researching land is absolutely crucial, and we have so much to ask. And right now we're going through wars in the world that have to do with land. So land disputes are being settled in courts, but they're also being fought in wars. So I think this issue is absolutely urgent. And so I had so many questions to ask, but I'll do it in the break. I think about the wrap up, the kind of trying to conclude and stitch things together, that was very important because I think it really shed light and organized a lot of the findings. And about these finding one and finding two, I mean, the fact that we're talking about still very liberal politics, and that you're concentrating on courtrooms, I can imagine that those two things are interrelated because this is what courts are about and this is what they do. And if you looked elsewhere, I think you might find if you were looking at the social movements and at framing by these movements, maybe different things would emerge. But I was wondering, so I have two questions. Can you spot any paradigm shifts in the empirics that you're looking at? I mean, we have this late liberal kind of way of managing identities and territories within liberal institutions. This has been around since multiculturalism, decades. In Brazil, we're going through an intense shift of this paradigm right now to a different way, a different imaginary, a different way of understanding territories and identities. Can you spot something like this in your empirics? Is this emerging somehow? And I think I'll leave the question at that, and then we'll talk more in the break.
So there are a lot of is very, very different. Okay. No, okay. So we'll do there first. We'll just who wants it? Everybody.
Oh, thank you very much. I will be super short. It's more like if the experts on Colombia could tell us like the main challenges of the institutional inertias now with a new government to advance in a more like transformative land justice direction, because we have listened a lot about like these new ideas of jurisdicción agraria and other like attempts to advance in this way, and also people coming from social movements and agrarian movements that are now in the government. So what are the main challenges and also like maybe new innovations that they are doing in the new government? And if you could share it with us, and also like in general, if you could share also like how has changed like the distribution of the ownership, especially for women, if there are like special roles of women's movements in this fight, like in the PhD course we were seeing about the Marcha das Margaridas, how like more like from the ground movements are taking, you know, more importance now in the context of the region. So if you, Latin America in this case, so you could share a little bit of that experience. Thank you.
I think
thank you. And this has been a great panel. Just a quick question. I understand that one of the motivations of this project has been to ask whether disputes over land are fundamentally different to other socio and economic disputes. So what have you found? What's different?
Then I think we'll now you need to raise your hands again if you want. If you have some more comments.
Thank you very much for this wonderful presentation. I have several questions that I'll go over during the break, but let me just draw some attention to the input dynamics of the litigation process and echo the innovative aspects that Elena invited us to look at. For example, administrative law, which also resonates with yesterday's presentation of Alicia, the push towards global administrative law, and connect with the wonderful project that Namita has been pushing about the law in India, this wonderful website that sets all the laws and the colonial legacy. So in the frame of your research, what is the relationship between the type of lawyering and the claims that arrive to courts? There's been a wonderful push in Guatemala, for example, towards indigenous lawyering. Does that change the narrative? In which senses? Just a bit to kind of see whether that is kind of a response to the stabilization of frames that Tatiana was talking about. Thank you.
Did I miss anyone? But
we have 5 minutes, and thank you all for fantastic questions, which of course we can't possibly all answer. So I'm just going to give everybody 1 minute to pick up what they would like, and we'll start with in the order we intervened in, if that's okay, Tatiana. Floor is yours.
Thanks. Thank you. Well, I would say something about the question on the structural thing. I'm not sure. I think it was Roberto. I guess we need to unpack what structural means in this situation, and especially when we deal with courts, because it's, I mean, the fact that judges come from the elites are not equivalent to the structural issues. And I guess we have some examples that work to show why the structural goes beyond the identity and the right of the background of the people. I think, like, if we think about the Constitutional Court, the Colombian Constitutional Court at the beginning, for example, then you had those elite judges that were part of a broader political moment. So we need to unpack the background of the judges and separate that from the political moments and debates in which the constitutional decisions take place, I would say, in order to understand what they're actually doing or not, and then how that tackles or not actual economic structural relations. Because I think we can find interesting cases, like counterfactual cases, in which you actually see more progressive and structural decisions coming from those judges anyway. I guess Jackie would disagree in the case of South Africa, maybe. But I just think that we need to unpack that. So the identity and the background of the judges is not equal or equivalent to the structural issues that they could tackle, right? And then I think the Colombian situation now regarding those actors that used to be part of the social movements and are now in the government is actually what is showing the limitations of constitutional law. And as we have discussed for the Colombian case for a long time, that we need to pay attention to administrative law. That's exactly what is showing that. So those actors are now in the state, and they're like moving a lot of things that were quiet or still for a long time, but they're not mobilizing, of course, judicial decisions. They're just mobilizing new things, not necessarily under a comprehensive public policy of redistribution and enforcement of land rights. So and also there's, like, we see in the state now the former divisions that they had outside of the state. So there's a lot of people that were part of the agrarian movement or that used to work with peasants. And then there's a lot of challenges and tensions with indigenous rights and Afro-descendant rights. So it's one of those situations in which the actors of social movements getting to that become temporary bureaucrats, but they are not necessarily changing the state of the logic of state agencies in order to move towards a more stable or structural situation.
Thank you,
like 2 minutes. Sorry.
Fantastic. 1 minute, Anna.
Yeah, just about the Fraser's frame. Actually, we are, so look forward to our next paper to be published, because we are actually, I guess, including participation aspects into a form of redistribution of power, not only the redistribution of material goods, but redistribution of power relationships, and participation goes into that. Thank you.
On the South African expropriation story, there's no question in my mind. I'm one of the people who believe that you do not have to amend the Constitution, that the Constitution already allows you to expropriate without compensation. There's a whole list of things that you have to compensate, market value that you have to consider regarding compensation for expropriation. Only one of those is market value, and it's not the top one. And so there are other things such as the nature and the use, the nature of the dispossession or of the acquisition, the use of the property, the extent of state subsidies already received, et cetera, et cetera. So I'm one of those people who say you do not have to amend the Constitution. The problem is not the law, the problem is the government. Regarding the question about, this is something that I've been thinking about a hell of a lot. Why is it that land judgments in general in South Africa are more radical than socioeconomic rights judgments? Now, I have to say that socioeconomic rights judgments, almost every single one has gone in favor of the applicants as well. The applicants in South Africa are all marginalized, disadvantaged people. Nobody litigates socioeconomic rights from middle class or above basis in South Africa. And I once asked the Deputy Chief Justice about that. And having now looked extensively at all the land judgments, I now realize why, part of this. He dedicated himself to the land judgments. He's from the Pan-Africanist Congress, and their focus was always on land. So I think that there was a focus on land, and that being rural land. And these pieces of legislation, the Restitution of Land Rights Act, the LTA, and ESTA, relate all to rural land. And the legislation, in fact, is pretty radical. And so the judges can't really, they do read some, there is some scope to be conservative, but it's really all, the push genuinely is all towards granting the land rights to dispossessed people. So I think the failure in the South African case came in when it came to urban land. So housing, urban land, where you see a clash between property owners, still largely white, and unlawful occupiers, almost exclusively Black. That's where the problem lies in South Africa. But with land rights cases, when it ultimately makes its way to the Constitutional Court, it will be ruled in your favor.
Thank you. Yes. I just wanted to quickly, say that in India, and this sort of goes to the point that you were making, Elena, I sort of disagree with the idea that the case studies are looking mostly at sort of liberal frames of property and so on, because at least with the Forest Rights Act that I was mentioning, the goal is to reverse a century of injustice. The rights that are being protected include like individual and community rights to land, water, and forests, but also rights to collect minor forest produce, exactly the sort of stuff that Marx said was outlawed by the laws on the thefts of the woods. So that conversation is happening in a very different frame as compared to what are the initiatives that are coming from the government, which, going back to the panel yesterday on technology and the law, most of the initiatives that are coming from the government are really within that frame of using technology and digitization and so on of land records and so on within that sort of liberal economic frame. But the stuff that is coming from the social movements is counter to that. And what we have is this contestation really between reforms that are coming from the government and reforms that are being pushed by these social movements. And both are sort of jostling for space. There, I also want to mention that Indians are now thinking, in the grassroots movements, are thinking of bringing about a climate law. And again, to safeguard some of these, rights as land, water, forests. And to Roberta's point, I think that there are two things. One is that I think that I do not know about the US Constitution. I do not think it was very transformative in that sense. But the Indian Constitution, possibly the South African Constitution, are transformative. And for India, we have the Constitution of 75 years. So lawyers have been sort of trained with that idea in mind. So that perhaps goes against the original structuring idea. On participation, we did have 2 Indigenous members in the Constituent Assembly in the drafting who were responsible also for the drafting of the clauses. And we have these. I really think that, it's not just courts. That is not where the hope is coming from. Courts are just one tool in the arsenal. There is a huge social movement. They're using every tool in the book. It has been happening. The Forest Rights Act was passed in 2006. People were trying to reverse this injustice ever since we became independent. And that speaks to Thalia's point about, there's a lot of changes happening at the statutory level, not just at the constitutional level, but it's where they intersect is where, we can have some more progressive, nationally. And finally, the Vedanta case, which was decided in 2010, it was about the Dongria Kond community, one of the most vulnerable tribal groups in India. It pushed the law on consultation, beyond consultation to consent. So it's the only case that we have found in our case studies, which says there is
South African.
They also have free prior informed consent. Yes. Okay. Perfect. So we have these progressive cases which are talking about free, prior, and informed consent of the communities. We also have a law on the right to fair compensation and land acquisition of 2013, which again talks about consent of affected families. Now, whether that is being implemented properly, yes, there's a lot of difficulties in implementation, but at least we have that in the law.
Thank you.
Thank you. No, I don't.
don't want to add too much. It was a proposal, right? I think that what I'm trying to do is some ideas for us to think about it. It would be crazy of me to think that it's comprehensive and that it's just a frame for all of us to think together. So thank you all for your comments and ideas.
Wonderful. Thank you so much.